I'm Tian Wei, and welcome to Dialogue, coming to you live from Beijing on CCTV News. Reform of China's legal system has become a major priority following the all-important third plenum of the 18th CPC Central Committee. Important and significant changes are being introduced aimed at making the courts more independent and more transparent. But just as important are measures to boost confidence in the system, including an end to confessions obtained through torture. So what difference will the reforms make to the rule of law here in China? Will justice not only be done, but also seen to be done? To discuss all of these issues, I'm joined here in the studio by Mr. Edward Lehman, who is the managing director of Lehman, Lee & Xu. He's been practicing law here in China for a few decades already. And also joining us in the studio, Professor Li Zhaojie. He is with the law school at Tsinghua University. Professor Li, welcome to our program as well. Before we go to a discussion, gentlemen, with the two of you, the two lawyers, let's take a look at this background report.
China's Supreme People's Court decreed on Thursday that forced confessions must be eliminated, and also called for a more cautious approach to the death penalty. Inquisition by torture used to extract a confession, as well as the use of cold, hunger, drying, scorching, fatigue, and other illegal methods to obtain confessions from the accused, must be eliminated, the Supreme Court said in a statement posted on its official microblog account. Far-reaching reform of China's legal system was agreed during the third plenum of the 18th CPC Central Committee, which concluded last week. Another major change was the decision to scrap re-education through labor. The use of forced confessions started to stir concern following the case of She Xianglin. In 1994, he was tortured and confessed to murdering his wife. A death sentence was imposed, but changed to 15 years imprisonment. He languished in jail for 11 years before being suddenly released after his wife turned up very much alive and well. The Supreme Court announced its new approach to the death penalty, saying adequate evidence must be furnished and that only experienced judges could handle capital punishment trials. Nicholas Bequelin, a senior researcher for Human Rights Watch, says the ruling is an encouraging sign that the government is responding to pressure from society demanding better rights and protection during criminal trials.
27 provisions issued by China's Supreme Court in order to avoid any miscarriage of justice and also to end forced confessions. Professor Li, from your professional perspective, will these measures work this time?
I suppose it will work, but not very easily, because what we have right now is a country with the tradition that does not quite regard the rule of law as sort of achievements and importance.
So what are you saying? Are you saying as long as the culture, if it's not changing overnight, we're not going to have very much the judicial justice?
You're right, because the cultural burden is still heavy, and we have the saying, Rome is not built up overnight.
All right, Mr. Lehman, are you as confident or less confident?
I admire that they've made these statements. They've drawn a line in the sand, and they're trying to attain those things. When the Declaration of Independence was set out, when we wrote our Constitution for the United States, I mean, of course, not all men were created equal at that time, and there was slavery, right, and things happen, and they do happen, and they do progress. So I am really encouraged with this. I think Professor Li is correct. The devil is in the details, or God is in the details. How do we do this?
What are the details then?
Yeah, there were some rules that came out in 2010 about new criminal procedure laws that have been around for 3 years now that they've talked about implementing and trying to implement, and it's still been difficult and tough going with that. So the details are in the civil criminal procedure law for China, which came out in 2010, and some of them are proactively saying, in 2009, some of the statistics I have read, that in criminal trials, 99.9% of all trials ended in conviction of criminals. So obviously the government has looked at this and said, this is probably not correct. There's got to be some innocent people out there. And so they've rewritten the criminal procedure laws, and now it's a question of implementing it, and that's the difficult thing. Big country, tough to administer.
But what are some of the details you are really looking at? If you say the devils are in the details, what are the details? Give me a list.
Yeah, from what I understand, and again, I think a lot of this is open even after this declaration has been made, but from the criminal procedure laws, I mean, proactively in these confessions, the prosecutor has to proactively show that this was not a forced confession. That's actually a little bit different. So the burden is on the prosecutor and not on the defendant himself to say that this was not a forced confession. But forced confessions are a phenomenon that happen all around the world. I mean, it's not just within China. Japan has a high 90% conviction rate or above
and your
as well.
point is, I'm getting mixed signals coming from you. So what exactly is your point?
Well, but my point is that you're right. I mean, the devil's in the details. I think this is sketchy right now. I mean, they want this to happen, and the details have not yet come
If that is sketchy, quote unquote, according to Mr. Lehman, Professor Lee, to what degree do you think these notice or orders coming from China's Supreme Court could be in detail, and what are the details are you looking for if you say this time it can be implemented, and it can be implemented almost completely?
Well, first of all, I must say that this notice represents enormous progress in terms of criminal proceedings in our country. While I say it's not a very easy way sort of to achieve the end overnight, I said we do have the culture that the traditional culture that is a pro sort of judicial independence.
But the culture can, as we said already earlier, the culture cannot be changed overnight, and it probably takes the rule of law in order to change the culture. It's not the other way around. Right. So what about now? What are the details you as a legal expert are looking for?
Well, you see, we have a very hardcore principle in criminal proceedings we call the presumption of innocence. See, if you explain this principle to sort of professionals, it's fine. But if you explain this principle to lay people, see, how could I believe this, this guilty person
You're still talking
innocent?
about culture issue. However, I could read a quote to you. Mr. Shen De-yong, who is the Executive Vice President of the Supreme People's Court, has called for efforts to prevent miscarriages of justice. And he even said something similar to this. He said, it is even preferable to spare guilty people than to hand down wrongful punishment to the innocent. Yeah. I'm not sure if I got 100% exact quote, because this is what the media has been quoting. Right. I don't know exactly what he said 100%, but this is probably the meaning he's trying to express here, Mr. Lehman.
Yeah, my understanding is from Vice President Shen was that he went on even to say that if a guilty person goes free, heaven will not fall. If an innocent person is put in prison, then heaven will fall. So, I mean, I think that those are very strong statements. I'm not sure that they were plugged into exactly what are the specifics you're looking for today on why it's going to be different. What I think is different is that the attitude and of the leaders is one of change. And by having a Weibo account and by having these types of things, they're looking for transparency. They're trying to find a way out.
And we don't want to miss out some of the messages you just gave now. Yes, indeed, China's Supreme Court has opened its own Weibo account, which is China's microblog, one of the most popular microblog. And also it has opened up a WeChat, which is also a social media, Twitter type of thing, quite popular in China. Both have the biggest amount of users here in China. It seems that the message is they try to be as transparent as possible. Having said that, though, we still want to come back to the details because the details might involve the amount of power that the police have when it comes to forced convictions.
Yep. Exactly.
And therefore, what exactly is this power balance in a way? The court, also the police here in China, and what China also calls the procuratorate.
Yeah.
Right. Well, what I see, just as an outside observer on all this, is that it's like Abraham Lincoln said. I mean, if you want to find about somebody's personality, how they react, don't look at adversity. Give them power, and then you can see how it is. And with the police, the issue here sometimes is that they have the power, but having power doesn't always mean that you need to use that power to its utmost degree. For example, with putting people in forced labor camps for 4 years without trial, they have the power to do that. But should they do that? That's the question. And this is the balance, and this maybe goes back to Professor Lee's comment about culture versus if you have the power, why should you always use the power? You should use the power in a wise manner, in a judicious manner.
It's wonderful to have cultural analysis, but I think some of the important things can only be done if we're getting to the facts and the details and the reasoning. So let's go to the reasoning part. What exactly is the share of power? Let's just say between the three organizations that I just talked about, police, procuratorate, and the court. What exactly is the general situation here in China, Professor Lee?
Well, not sort of in those majority cases, but some cases, to my knowledge, are that the policemen, prosecutors and judges work together, to sort of investigate and make a judgment over a case. And this is not what our designer of the political institution expected, because for a good judicial system to work, we must keep the court independent of the police and the prosecuting institutions. Well, when you talk about details, now all of us know that recently the torture and the wrong cases caused by torture these days are very phenomenal in China, and that has done much damage to the image of the country, to the sort of confidence of the people, and that must have to be addressed. I think.
Well, give me some examples, if you can.
Well, Zhao Zehai is a typical case, in that, to that effect. I mean, this person was sort of an innocent person, but through this torture and the police brutality, he was forced to confess that he was a murderer. But a few years later, the person supposed to be the victim, came out live. So I mean, this is sort of has caused nationwide outcry. How could you do the system of justice like this?
And therefore, your argument as a result is that the power of the police should be on check in a way. But then, if the system is working as it is, the court should have both the power and also the eagerness to check out whether the procedure has been a fair one and whether so-called quote-unquote the conviction have been forced or not, and why, according from the systematic analysis, if you have, why the courts, particularly at local level, would not be necessarily 100% able to check out on these cases and try to correct these cases.
Yeah, I mean, difficult to do, certainly. I mean, and even...
Yes, it's difficult to do in any country. And let's just focus on China now.
Right, and Vice President Shen said, I mean, in those instances, that in that statement that he made, we talked about earlier, he said that individuals should be held responsible, judges should be held responsible. And I think that that's a very significant statement, because they should break through the immunity of saying that they're personally responsible for these kinds of cases, and this will make them pay attention, and so that they would be liable for litigation.
So what would motivate these judges and motivate courts at local levels to fulfill this part of their responsibility?
I think personal liability, so that they have to take a look at it. They have to, because I think judges want to keep things simple in
personal
all
liability,
countries.
and therefore there's probably another aspect of the story, that is, what is the relations between, let's just say, the local government and the local court, whether the local court officials are being promoted bureaucratically in something government-like system, and therefore are they more motivated or are they less motivated to fulfill their job as someone from the court?
This is exactly one of the source of our problems, because our court, particularly the local court, is part of the local government, and their salaries, they are sort of
the bureaucratic apparatus is established like what is being practiced in the local government. It is not the local government, by the way, Professor. We have to distinguish these two concepts very clearly.
Well, but anyway, I think the interference, in our court system, in the court proceedings of trial, either civil or criminal, is pretty sort of regarded as something that quite
So how to change? That's what my question is more about.
well, build up, institutional capacity to keep, our courts independent.
Institutional capacity, in what way can you build it up?
You have to separate, I think, the sort of, the linkage, resulting from interest. Let's say, let's just put this case. If the judges' salaries, if the judges, perks, the judges sort of, other things the judge enjoy, are not to be determined or decided by the local governments, local, bureaucracy apparatus. I think that is sort of, a very important institutional material incentives to sort of encourage those judges, those courts, to, sort of do their job independently.
We have already seen quite encouraging signs over the past few months and weeks, particularly since the third plenum of the CPC Central Committee, particularly about the abolishment of the forced labor camp, or so-called re-education through labor. And many say it's a big step forward. And therefore, can all of these steps, as being provided by the provisions coming from the Supreme Court, follow up? How realistic an expectation we should have about the speed and also the efficiency of all of these measures? Gentlemen, we have to continue our discussion after this break. We'll be right back. Welcome back. You're watching live edition of Dialogue. With me in the studio, once again, we have Mr. Li Zhaojie, a professor with the law school at Tsinghua University, and also Mr. Edward Lehman, who is the managing director of Lehman, Lee and Xu, a law firm based here in Beijing. Earlier, gentlemen, you helped me and my audience to understand the significance given the recent decision of the Supreme Court here in China to make sure there's not going to be much miscarriage of justice here in this country. However, let's continue a little bit on that path. Mr. Lehman, what do you consider as some of the possible speed of change for the better about China's judicial system? Because we mentioned earlier, there's already the abolishment, very clear, being made by the Chinese Communist Party and also CPC's third plenary about the labor, forced labor, or a re-education through labor. And now, how much expectation should we have?
I think that they're going to move with all cautious speed that they possibly can. I mean, I think that the viewers have to understand the infrastructure is not, I've been here for 27 years. And when I got here, there were only 4 legal programs, really, and they were more political than legal. And so what I'm saying is the infrastructure for legal education and for people to understand this whole process has only happened over the last 30 years. And so that's part of the problem is the infrastructure of teaching judges, teaching lawyers, teaching. And one of the key problems I see, and which came out in the third plenum, was that they said we want to protect legal aid and we want to promote legal aid.
Right.
That's where we need help.
And also protect the lawyers who are doing their jobs.
That's right. And lawyers who are doing their jobs are oftentimes jailed in these local issues and local situations, and that should not happen. There should be a protection and an immunity from that, and there should also be some level of, there's also a stigma for people who decide to take on these cases. They're considered to be bad people, and that should be abolished. So what I'm saying is it's lopsided. The government has endless amounts of money to prosecute against maybe innocent or guilty people, and then there's no defense lawyers that are willing to take these cases. This is a big problem.
I noticed one word you've been using repeatedly, that is should and should and should.
Right.
And of course, there's a long list of should-to-do things that China should have in mind. However, the question is how to do these should-do things. So, Professor Li, I wonder whether you have already some remedies, where to begin with, or it has to be an overall systematic change all at the same time.
I think this is one of the highlights of this third plenum decision to sort of make the reform to our judicial system as a top priority, one of the top priorities, and I believe that will be sort of followed by the sort of concrete and detailed actions. Well, to talk about the speed of the change, I think if given sort of what happened past 2 or 3 years, I think the change is pretty speedy, and this is caused by a change of factors. And one of factor to me is this: what happened in Chongqing. The torture committed by Wang Lijun and his likes. That has really the violation of law, the sort of contempt to.
And of course, that is one chance when the public and also the officials at different levels got informed about these kinds of miscarriage of justice here in China. And of course, the public calls for change. Talking about the public, gentlemen, there's another very important aspect of this notice issued by the Supreme Court. That is, to what extent the so-called public opinion and the media should play a role in the final decision that the court is making about whether one person is innocent or guilty. We see that debate in different countries, but now we also see the phenomenon that the media and the public trying to come out and protect what they consider as the right person or the innocent person. On the other hand, we also see that some of the accused and the defendant lawyers trying to manipulate the public opinions and the media in order to achieve some of their goals. So this very delicate balance is always an interesting case, Mr. Lehman.
Yeah, no, it's one we see in the United States all the time, and it's become a phenomenon here that has been a rapid developing phenomenon here. And again, I think justice needs to be blind. I think justice has to not listen to the media. The media is not looking at evidence. The media is not looking at the rules of civil procedure, nor are bloggers, nor are netizens. I think that they serve an important purpose as a watchdog, but I don't think that they can say someone is guilty or innocent, and that's left up to the court system. And I think the court system has to be independent from that and should not be moved or swayed by that in any way, shape, or form. It should maybe bring it to the attention that there should be some
interest. In the United States, we saw a very obvious example of O.J. Simpson, for example.
That's right.
It's on TV shows 24 hours a day for so many years. But Professor Lee, that might be one case in one extreme. There might be other cases in the other extreme. So once again, this balance, particularly in today's China, when the rule of law is still not yet being implemented 100% in every corner of the country, when the public and the media can still serve as an important observer on the sideline, what should be that balance be?
Well, I think the balance is pretty delicate, given the present situation in China, which is in a rapid transformation process, and also the media has become increasingly proactive. Well, I think the balance. I agree with Lehman. First of all, the media should keep neutral by not taking positions of each party, and secondly, I think the media should be well disciplined and self-restrained, because recently we have the cases the media was purchased by the interest parties. So that is, I think, is a very bad case of miscarriage of sort of a push or sort of encourage to the miscarriage of justice. That means the bad role of media in this regard.
It is easy, of course, to criticize the media. It's also easy to criticize the public. It is also easy to criticize that the law has not been implemented 100%. But many might wonder what should be or what are some of the fundamental reasons why things are like this today. Because some say, Mr. Lehman, China still is quite new to the issue of rule of law.
Sure.
China has been learning from the Western countries since the Qing dynasty, the end of it, trying to implement some elements of that legal system. But obviously, China's political system is different today from many of the Western countries, so you cannot borrow everything there. And therefore, there is an interesting process that we're witnessing right now.
Absolutely. I mean, the Chinese law is based on the German Code of 1896, and so that's what they've adopted it from. And I think the reason we have a very difficult time, Professor Lee and I, answering the question about the speed is that when they abolished torture in the United States was probably around 1966 with a case called Miranda versus Arizona.
That's right.
And so that was law. Do you understand? So the minute that case happened, Mr. Miranda was a very bad man who murdered someone, but he wasn't read his rights, and he was beaten up and abused. And the Supreme Court came down with a decision, and that is law. That's what we call stare decisis. So from that date forward, the whole nation has to follow that because that becomes legal or illegal.
But China's system is not necessarily on the case
it is not.
by case.
It is not. That's the problem. That's the problem. That's what I'm saying. So it's done by the Supreme Court comments and interpretations.
All right.
And so that's why I can't tell you what speed this can be done with.
You
that's
say
why
it is a problem. It is the problem. Is that really the problem if China's rule of law is not being practiced in the way that the U.S. has been doing, with mainly using cases to specifically show how certain laws should work?
Well, I would say case law, with quotation marks, plays increasingly a positive role in sort of developing Chinese characterized rule of law. Thank you. And also, secondly, we certainly have taken reference to this Miranda case, so-called Miranda warnings. You might have noticed there's a heated debate among the scholars, among the judges, among the prosecutors about the right to silence. And so that is, one institutional way to sort of avoid a miscarriage of justice. Sort of confessions, or admissions out of torture, out of sort of, other brutal activities must be excluded from the court. This is what we call the rule of exclusion. And that actually has already been in the mostly, revised the law of criminal procedure in China. But the question is implementation. And implementation, in that regard, I would like to say that we have to educate our people. For miscarriage of justice, today it's you, tomorrow it may be me.
Right.
So, this kind of conception must be built up, and then, sort of belief in law. And there's another sort of a decisive element to sort of push the progress.
So once again, Professor, my counter argument would be that would take a long time. So how can we solve this problem as soon as possible? Make sure law can be implemented as much, at least, as possible, Mr. Lehman.
I think that they're making steps in the right direction. They've outlined it in the rules of civil procedure and in evidence. What you need is an advocacy system. The prosecutor is very well endowed and has money and everything else. What you need is the other side needs legal counsel. What you need is you need the right to remain silent. That's and so I think that will happen, but it'll be a slaughter unless you have assistance of defense counsel with people, because everyone's going to just roll over. So that's the problem. Until we have enough lawyers. We only have 200,000 lawyers in the country. How many are practicing criminal law? Not so many. And so, this is an issue of infrastructure, which I think will be addressed and changed. I'm optimistic, though. I'm optimistic. I think it's a step in the right direction.
And final word from you, Professor Lee?
But with great measures. The Li Zhuang case is a great lesson about this, we call the iron triangle between lawyers, prosecutors, and judges. That must be strengthened, to avoid those, the future possible miscarriage of justice.
Right. There are many encouraging signs we have been witnessing over the past few days, few weeks, few months, and even few years. But once again, how can we make sure those signs are not just going to be signs forever, but rather going to be a systematic overall change? We're going to look forward to those changes. But we want to thank both of you, gentlemen, for coming over to our studio. Professor Li Zhaojie and also Mr. Edward Lehman. Thank you so much, gentlemen, for being with us. And thank you for watching. I'm Tian Wei in Beijing. Bye for now.